Thank you all who've joined us here in the hearing room for showing up. We are going to start. We have for today's agenda, we'll be focusing on social services. We have a pretty extensive vote-only calendar. We're going to start, however, with our issues for discussion, which begin on page 10 of the agenda. So if I could have Department of Social Services come on forward. We'll begin with issue 14, May revise caseload adjustments. As soon as my third committee member arrives, we'll pause and go through the vote-only calendar, if that's okay with you, Senator Stone. Great. Good afternoon, Director.
Good afternoon, Chair Mitchell, Senator Stone. Yes, so we are starting with the caseload.
Yes, sir, with page 10 on your agenda.
And the questions appear on page 12.
That they do, sir.
The summary is as in the report, just a comment on the caseload growth in IHSS. This is fundamentally demographics, just the underlying changing of the population of aged and disabled who are Medicaid eligible. The increase in the hours per case is presumably a reflection of increased need through the QC process that the department does with counties. We get to sort of validate that, in fact, the hours and task guidelines are being appropriately applied. So if there are any concerns that there's either over allocation of hours or under allocation, those are flagged with the counties involved. In terms of updated data relative to overtime costs, we have not come up with any data that changes our projection.
Because you only measured 1 month.
We have 1 month which has been fairly consistent.
With your
right
estimates, okay. Any questions before we move to the LAO, sir? LAO.
Thank you, Madam Chair. Ginny Bello with the Legislative Analyst's Office. As your agenda indicates, we've had a chance to take a look at the department's estimates for the major programs, and we don't raise any concerns at this time. We were able to look at some more recent actual data and compare it to what the department is estimating, and it all looks reasonable. For IHSS, we were even able to do that to the level of looking at the average hours per case as well, based on the data that the department provided, and we feel comfortable with their estimates.
Excellent, thank you. Finance? Any public comment on the caseload adjustments based on May revise?
Madam Chair. I was just hoping we were going to get to question number 2 before we go to public testimony. What factors are contributing to the increases in caseloads and hours per case growth in IHSS?
Yes, Senator. And what I was saying earlier was that's largely a result of the demographic changes in our state, and we expect those will sort of continue at sort of a gradual rate as the population ages.
Would you say we would expect a constant rise every single year because of the rapidly aging population?
Fundamentally, yes. I mean, I think that, and keeping in mind that IHSS is, of course, a relatively cost-effective alternative to institutional care. It's something that we encourage, as well as being hugely preferred by most consumers. Right. And then the hours is, we believe, reflected in the appropriate use of the hour task guidelines, but is subject to QC review.
How many hours? over the past few years, we were talking earlier that we saw just like a significant jump in the number of hours in the past year in comparison to other years. What would account for that spike, if you will?
Sure. Pete Chervinka with the department as well. There were two factors for that. One was the restoration of the 7% reduction at the beginning of this year. That's a big one. We've also seen a relatively significant growth, although not huge in terms of overall program participation. We have seen the sub-portions of the program that receives protective supervision services, which is automatically the maximum hours in the program. That percentage of the caseload has been growing relative to the rest of the caseload, as well as the proportion of children with autism who are being served in the program. So both of those tend to have relatively higher than average needs. And as they grow as a percentage of the total caseload, the rate has gone up in terms of authorized hours as well.
Then I would assume part of the spike for next year will be the beginnings of the implementation of the newer minimum wage. I'm sure that'll have it.
And the minimum wage has an impact in a number of counties as well. And will continue to do so going forward.
Yes.
Yeah.
Thank you.
Yeah.
Okay, keep that handy in case I need. Okay, thank you very much. I called for public comment. There was none.
I'll make a motion.
I'll entertain the motion to approve the May revised caseload estimate changes, and I'll ask you to call the roll, please.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
This is on the caseload revision. Aye. Thank you. That's out with a 3-0. Keep your seats, but if you just let me go back to my vote-only agenda since I've got a full subcommittee for a moment. Gentlemen, what I thought I would do, okay, where was my issue? Oh, my issue is here, and my issue is, here. I think what I will do, just for simplicity, let me start by taking the gum out of my mouth. My mother would want me to do that, is go by department, and then when we get to social services, we'll go by, kind of program within the departments, just to keep it simple. I think it's easier for everyone to follow. So again, we are returning to the vote-only section of our agenda. We're going to start with item 5160, issue 1, Department of Rehabilitation, the supported employment rate increase. I'll entertain a motion.
So moved.
Call the roll.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
That's out with a 3-0. Issue 5175, Department of Child Support Services. It's the May revised estimate and the Child Support Non-Custodial Parent Employment and Demonstration Project carryover. So moved.
So moved.
Call the roll, please.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
Thank you. We'll move on to Health and Human Services Agency, Office of Systems Integration, Department of Social Services, their BCP. I'll entertain a motion.
So moved.
Call the roll, please.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
Thank you. Department of Social Services, the State Hearings Division, their BCP. Motion, please.
So moved.
Call the roll.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
That's out 3-0. Moving on to 5180, Department of Social Services, CalWorks, on issues 2, 3, and 4, the minimum wage impact, TANA funds transfer, and the reappropriation of CalWorks funds for the housing support program. I'll entertain a motion.
I move approval on all issues you just cited.
Thank you. Call the roll.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
That's out with a 3-0. Under Department of Social Services, CalFresh, I have a quick clarification on issue 5, the able-bodied adults without dependents automation. I understand the issue has come up in the work group with regard to the policy letter that's required by January or shortly thereafter to ensure that we've got a timely SAWS implementation. Do we expect to meet that timeline?
I haven't heard anything to the contrary, so I can certainly circle back and get you further information.
I would appreciate that. Before we close it out, I wanted to make that ask of you.
I'll move that.
Thank you. Will you move item 5 and 6, as well as the California Food Assistance Program minimum wage impact?
Yes.
Call the roll, please.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
Thank you. That's out 3-0. Continuing with the Department of Social Services, Child Welfare Services. There's 2 BCPs, trailer bill, and a reappropriation request.
I'll move all those 3 issues.
4.
4. Issues 8, 9, 10, and 11, correct?
No, 7, 8, 9, and 10.
7, got it. 7, 8, 9, 10.
Thank you. Call the roll, please.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
That's out 3-0. Moving on to 5180, again, Department of Social Services, in-home supportive services. We're going to take issues 11 and 12 separately. Issue 11, IHSS minimum wage impact. I'll entertain a motion.
So moved.
Call the roll.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
That's out with a 2-1 vote. Issue 12, universal assessment tool. I'll entertain a motion.
So moved.
Call the roll.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
That's out 3-0. Final item for vote only, 5180, Department of Social Services, miscellaneous. This is the commodities supplemental food program transfer. Call the roll, please.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
Thank you very much. That's out with a 3-0. We'll now move on to 5180, Department of Social Services, CalWorks. We'll be talking about issues 15 and 16, beginning with item 15, program parity, page 13 of the agenda. Thank you for your patience.
Thank you, Madam Chair and members. Just a note, thank you for your support of so many of our items on your vote-only agenda today. It means a lot to us here at the department to make these programs work for you. On issue 15, the ARC program trailer bill, we appreciate the staff recommendation here. It became apparent almost immediately that we made a major mistake in our trailer bill. We plan to retract it and substitute language after working out the issues with stakeholders. State law has for many years required that resource families receive an AFD-CFC rate, and our language disturbed that longstanding provision. We intend to fix that.
We appreciate the
We'll bring
acknowledgement
language
of
back
there.
for
Thank you.
consideration that doesn't have these flaws.
Excellent. Quick question. When will your new language be available?
As soon as humanly possible. Meetings happen today. There's more discussion after the hearing today. We're on it.
Got it. LAO, any comment? Finance? Any public comment? Okay, seeing none, we'll hold the item open. Moving on to item 16, trailer bill on the Workforce Innovation and Opportunity Act Career Pathways, your 24-month time clock approval.
This is simply a trailer bill proposal. We think CalWorks clients should have the same opportunities to pursue WIOA pathways as other people in the general population. We don't want work participation rate requirements to be a disincentive to that participation, and this language would accomplish that intent.
LAO? Finance? Any public comment on the 24-month time clock approval?
Kathy Sunderling with the County Welfare Directors Association. We support the proposed trailer bill language. Thank you.
Thank you very much. Any further public comment? The item's been moved. Please call the roll.
Senator Mitchell,
Aye.
Senator Monning,
Aye.
Senator Stone.
Thank you. We'll transition to Child Welfare Services, issue number 17, the trailer bill language around the child near fatalities reporting and disclosure.
Madam Chair, members, your agenda is fairly lengthy and detailed in this respect. I'm happy to answer questions about this, but a very brief overview. For a couple years now, federal guidance under the Child Abuse Prevention and Treatment Act has required the disclosure of certain information and records in the cases of both fatalities and near fatalities. In the case of California, we had several years ago in SB 39 a negotiated agreement on disclosures for fatality cases when a child dies in the welfare system. Recent federal guidance also clarified the requirements for disclosures in near fatality cases. California does not currently have any law in its books governing disclosures of information and records in near fatalities cases. We have trailer bill before you this year that would, for the first time, codify those near fatality reporting obligations. In this particular instance, well, last year it was a threat. Now it's a definitive threat. The federal government has said unless the California law becomes compliant with becomes compliant with CAPTA by October 1st of this year, they will withhold our federal $3 million CAPTA grant as well as $1.8 million in the Child Justice Act grant that is received by the California Office of Emergency Services. So we see this as not a discretionary choice, but necessary to maintain those important Child Prevention Act funds here in California. This language does that. It's largely consistent with fatalities. We think, though, that it does have some important differences in the disclosures, given that in the case of a near fatality, the child remains alive and they should be entitled to certain protections of medical records and other things that in a case of a fatality would otherwise be different. So there is a difference there in the two languages approach to the disclosure. We have a letter from the federal government dated in April this year that confirms that both pieces of trailer bill language, we have a small paragraph for the fatalities to conform, but also for the near fatalities language, that if enacted, that language would in fact comply with CAPTA and be sufficient to guarantee continued receipt of these funds. Happy to answer questions.
I'm just reviewing the questions on page 17 on the agenda.
Sure.
If you could walk through those, that would be helpful.
Sure. So with regard to question one, a summary of the language regarding near fatalities and change to the language regarding fatalities. Let me start first with fatalities. There is, I apologize, off the top of my head. Yeah, it's at the bottom of page 16 on your agenda. The paragraph, the very last bullet at the bottom of page 16, there's a required additional disclosure of services, child protective or other services provided and actions taken by the County Child Welfare Services Agency, not otherwise disclosed within other documents that are required to be released. So it's kind of a catch-all provision that was added to the federal guidance for fatalities. And that's the change that's proposed in the fatalities piece. The near fatalities piece is rather long because it is new statute. So going back then to page 15 on your agenda, it defines a near fatality. It speaks to the overall condition of the child, not a particular severity of an individual injury. For example, a broken arm, if a child told their father, he broke my arm, we would all think that was serious, but that's not a near fatal incident, whereas a single injury, perhaps a hammer to the head or some other strange thing, would be considered and result in the child's overall condition of nearly fatal. We want to be clear that random third-party drive-by homicides, for example, are not things that a review of the child welfare practice in California would benefit from disclosure in those kinds of instances. So that's the fourth bullet on page 14. And then there's an explicit list in the next bullet of things: the child's age and gender, the date of the abuse that resulted in the near fatality, the date of the physician's determination, where the child was residing, were they in the home of the parent or foster care, and then the cause and circumstances of the fatality. And then the next bullet requires a description of the reports that were received, the services, child protective and other services provided, and other actions taken by the Child Welfare Services Agency regarding the abuse or neglect of the suspected or substantiated abuse or neglect of the near fatality victim or other children pertinent to the abuse and neglect of the near fatality victim, and a written narrative that includes the dates of reports, investigations, services rendered, actions taken, and the investigative dispositions. The distinction between the near fatalities language and the fatalities language is that in this case, the near fatalities language requires a description of those reports rather than the actual reports themselves. It's our belief that that enables a very careful review of what happened in the case and ensures adequate protections for the privacy of the child. Mm-hmm. The second to last bullet, all risk and safety assessments related to the near fatality victim are required to be disclosed as well upon request. We authorize 30 calendar days for those disclosures to occur. Again, we feel that time frame is important. There's often a large volume of information in these cases, and we want to ensure adequate time for the complete protection, appropriate protection of the still living child in that case. We do, however, allow that on the top of page 16, that bullet, if a county wants to adopt as a policy that its compliance with these provisions is achieved by redacting and releasing the actual record, it may choose to do so. But we require that to be a county-wide policy, not a case-by-case specific decision. And then because the child is still alive, there are privacy protections: names, addresses, phone numbers, ethnicity, religion, psychiatric, psychological notes, as all the things listed here on page 16 would be withheld from disclosure. But importantly, the bullet in the middle of the page provides that juvenile case file records that are not subject to disclosure pursuant to this section shall be disclosed only by an order of the court pursuant to section 827. 827 is the section in law that allows someone to petition the court for the release of juvenile records if it's determined to be in the public interest. In the case of fatality cases, the presumption in 827 is that the records be disclosed. The child is now dead, and there's no presumptive right to privacy. And we imagine that in the case of a still living child, a court would decide that the privacy concerns regarding a still living child should probably still prevail, but 827 does provide a mechanism for the court to decide if there's a prevailing public interest that outweighs that. And that's existing law. We are not proposing any changes to section 827 today. But I wanted to call out that the actual file contents are available. And then you see the effective date of January 1, 2017 in the language. That's the summary. So I'm happy to answer questions. I guess maybe that wasn't so much of a summary. And the fatality piece as well. So both pieces of language call for a 30 calendar day disclosure time frame.
And can you, since that's a change for the fatality scenario, can you please talk about, help us with that rationale?
Sure. It's simply a consideration that the amendment we are proposing for the fatalities language adds basically any other information not already disclosed, and that could be a lot or a little. Current law for fatalities disclosure says 10 working days, which is effectively 2 calendar months, 2 calendar weeks. I'm never going to explain this one correctly. 10 working days, roughly 2 calendar weeks, and we think going to 30 calendar days makes sense in this case, given the additional information required to be disclosed.
Does the statute affect any other entity's ability to obtain records, or is it only related to public requests for information? That's question number 3.
Yeah, question number 3, the answer to the first half is no, and the answer to the second half is it only related to public requests for information. These disclosures happen, and they're reported to the state. They're made public upon request by any member of the public. And I think question 4 we just answered.
We did. And 5 on the next page of the agenda, were stakeholders involved in the process of drafting the language? Because we're beginning to hear some concerns, which I assume will come up during public comment, about having just seen the language when May Revise was released, and some concerns. So were stakeholders involved?
As I alluded to in my opening remarks, we had an actual threat last year and now a real threat this year from the feds to withhold the grants. In the development of last year's trailer bill, we actually had a multi-month, very robust engagement with county staff, labor organizations, newspaper publishers associations, and child advocates. We found that really helpful conversation in the drafting of this language. Last year, we proposed language that was kind of a middle ground, and we continue this year to have language that is perhaps less of a middle ground, but compliant with CAPTA, meets the federal needs, and so we have had very little conversation this year with advocates, but very robust, and the language is largely identical to where we ended last year, except that we are more in favor of written summaries of the documentation this year than we were last year. We think that's a logical place to be, given the privacy concerns I described for still living children.
Okay. So stakeholders were involved last year. Language is admittedly different this year, and they have not been engaged this year because you are responding to the threat of loss of revenue from the feds, which has created a time crunch.
That is correct.
Questions from members? LAO.
Thank you, Madam Chair. We're continuing to review this language and appreciate the staff recommendation here to hold this open so we have a little more time to review it, and we'll let you know if anything comes up from our perspective.
Appreciate that. Finance? Public comment.
Thank you, Madam Chair and members. Kathy Sunderling with the County Welfare Directors Association. We do support the administration's proposed language. We think this language strikes the critical balance that we were looking for with last year's language and makes some key changes with regards to the public's right to know versus the right to the privacy of a child who is still alive in this circumstance. The child is in our care most likely and trying to recover from the physical and emotional trauma that they have suffered in the near fatality incident that we will be preparing the information and releasing the information about. So it's really critical to think about that, making sure that we do respect their privacy and allow them to heal, while also ensuring that the public understands what happened, has the context that they need to understand that, and also compare it to other incidents that may have occurred in that particular county or in the state. We don't think you can just take what's in SB 39 or in current law for fatalities and cut and paste it. We think this makes some thoughtful changes that will really strike that important and correct balance while meeting the federal requirements as approved by ACF to actually meet the CAPTA requirements and enable the state to continue drawing down its grant. We appreciate the recognition that the administration has made on these points and urge your adoption of the language.
Thank you. Appreciate it. Next witness, please.
Good afternoon, Madam Chair. Tia Orr on behalf of the Service Employees International Union in representation of 10,000 social workers across the state of California. We too believe this reflects a compromise on our end. We came to you last year in discussions about this, and we're also concerned that we haven't been brought to the table and haven't really discussed this. We have this year and really feel that the summary that they've moved to is reflective of the concerns that we have. As Ms. Senderling said, we have social workers who are still carrying this case. SB 39 was a different reality where the child has actually passed away. It's a different dynamic. We believe the administration heard our concerns, and this negotiation reflects those concerns that we addressed, and we would ask for your adoption as well. Thank you.
Thank you. Next witness.
Hi, Madam Chair. Bill Grimm with the National Center for Youth Law. We agree with the department that a change in law is needed to bring us into compliance with federal CAPTA. This is not that law. The state spends hundreds of millions of dollars on child protective services, and this is the sole way in which the public gets any access to information about how those agencies fulfill their responsibilities to children. I would say, first of all, that this bill is not consistent with the bill on fatalities because the fatality bill requires and provides for the public to have direct access to actual excerpts from the case records, not the written summaries, not a summary that an employee of the agency that may be under suspicion provides to the public. Secondly, this bill departs from the federal definition of near fatality and adds qualifiers and modifiers. We should stick with the federal definition of near fatality, which is the child who comes to the hospital in a serious or critical condition. Those terms, serious and critical, are medical terms that doctors understand. There's no need for California to depart from the federal definition. And thirdly, I would point out that this bill excludes from public disclosure certain categories of cases and certain situations that should not be excluded. It does not provide for all prior reports concerning this family to be disclosed. It limits those reports to a much smaller group of reports concerning the family and the child who was involved. And for these reasons, this is the wrong bill for California to pass, and we need to modify it so public disclosure, so that the window that we see about, through which we see about child protective services is open a little bit more than certainly this bill allows for.
Witness, please.
Madam Chair, members of the committee, Jim Ewert for the California Newspaper Publishers Association. We share the concerns as articulated by Mr. Grimm and his organization, but I'd like to underscore a couple of things as well. We're concerned about the built-in institutional delay in access to the information. The proposal has a 30-day calendar period, but it also would allow for a delay if there's a disposition of the investigation, whatever that means. We don't understand the need for that. All state and local agencies throughout the state of California have to comply with the California Public Records Act within a 10-day period. Every state agency allows for that. If there are extreme or extraordinary circumstances, the law provides for that. But the default is a 10-day period. We think that works well for every other state and local agency. It should work well here in this instance, too. With respect to the summarization of these reports, it allows the agencies to sanitize what happened in each of these instances, and it keeps from the public the actual information, the narratives, and the investigations that were done to determine for itself what happened in each instance. Now, the reason justifying these summaries that has been given by the department can be easily addressed by simply redacting information that would otherwise constitute an invasion of privacy of the child or the child's family involved in that situation or in that instance. We don't see why a summary is necessary, and in fact, the source documents are the actual best way for the public to make sure that when the department confronted a situation, they know what the issue was and how the response to that issue was dealt with. And that's the best way for the public to understand that. Lastly, the proposal would allow for any information for any adult whose activities are not related to the abuse or neglect in the near fatality to be confidential. And again, this allows or does not allow the public to see who may have been involved and what issues they were confronted as a social worker or other caseworker, and how a fatality, which may ultimately follow a near fatality, could have been prevented. And agencies for the last several years, decades even, have said that confidentiality of these individuals is absolutely necessary to protect them, and that they should be trusted to oversee these children. And year after year, we continue to see near fatalities and fatalities occur. It's time to open this up and to allow the public to see for itself whether these individuals are trustworthy. We ask for further consideration based on these concerns. Thank you.
Thank you. Next witness.